So, Millie, if Joe Biden issued executive order, fuck free speech, anybody who's a Republican and who advocates for Republican values is being arrested and thrown in jail, would you say, well, I couldn't quite say if that's unconstitutional because any court precedent could be overturned? Really, this is just a speculative argument relying on old court precedent in the First Amendment, interpretation of the First Amendment, to say that this is unconstitutional. Would you make that argument, Millie?
Joe Biden's DOJ actually tried to do that with Donald Trump.
Would you make that argument, Millie? Yes or no?
Yeah, actually, this actually did happen because Jack
These
Smith
guys are
tried to attack. Hold on.
Guys, I can never tell something's unconstitutional.
Hey,
You're a clown.
Now, let me be clear. You should subscribe to Scratch and totally become a member to get exclusive early access to videos. If you want to debate, you should join the Discord.
So Cringy and Polo voted for Harris. How are you doing today?
I'm doing good. Like, I don't like her acting like the Obama and Trump administration deportation policies are all similar. Obama never enacted the Alien Enemies Act. 95% of the people in ICE detention during the Obama administration had some form of criminal record. 61% of the people in Trump detention during Trump administration have no form of criminal record. Obama never authorized ICE agents to enter people's homes without judicial warrants. Obama never sent people to a torture prison without due process.
Obama prison. That's fine. Hang on. That's fine, Cringy. I don't care how Obama did it. He did it in his own ways. But he did have a law that was stating you can deport people that just came here illegally and did not do a crime. So he didn't enforce it. So fucking what? Donald Trump is enforcing it. The law is there for them to enforce, and Donald Trump is enforcing it. Yes. So what? He's not getting. They're not all criminal. They're not all criminals and have had prior crimes. It doesn't fucking matter. In the law, if you are here illegally and you have not committed a fucking crime, you can still be deported. I don't know why y'all can't get that through your head, because that's the absolute truth and fact of it. So hang on, I'm gonna go to Dale real quick, and then I'll come back to Cringy and we'll hear Polo. Go ahead.
So Cringy. First, I want your receipts, but I'll give you the receipts on mine. 65% of all the people that Obama reported or deported were within 150 miles of the border. So he insurrected that. He insurrected that act. The second thing about it is what was one of the most best-selling phones when Obama was in president? It was the BlackBerry. You didn't have people with these smartphones like we have now that all of a sudden they hear something and they got it out there throwing it in people's face. So the transparency is totally different. ICE agents haven't changed their policy since 2008. Go look it up. I believe it's DHS.gov, and you can look at their policies haven't changed since 2008. So if you're telling me that what they're doing they didn't do under Obama administration, no offense, I'm calling bullshit because their policies haven't changed. The way they do stuff hasn't changed since then.
Yeah, okay. So another thing, the Obama administration also ended workplace raids that used to happen. The Obama administration ended it. I don't know why we're acting like the Trump and Obama administration policies is like even remotely similar. And again, you just like left out the fact that,
I'm not saying that it was exactly the same. All I'm saying is that we had deportations and other presidents deported.
Ma'am, I never said it.
Illegals.
I said remotely the same. This is a
they're not the same. You're right. Obama. You're right. Obama put them in fucking cages, and he separated families, and he didn't have AC and all that for them. You're exactly correct. But Obama did it differently. Yeah, he did. Every president can do it differently as long as it's within the fucking law. As long as it's within the law. Every president did deportations. Every president did deportations.
So entering people's homes without a judicial warrant in order to carry out deportation is a violation of the Fourth Amendment. So
hang on.
To be against the law.
Well, great. And I guess those people that had that done, they'll go ahead and sue, and maybe they'll win some money. But let's go to Dale, and then I'm going to introduce the other people.
So my question is, you're telling me they're entitled to the law?
All right, bro.
Hang on, buddy. You're telling me they're entitled to the laws that says that we, the people that are born here or naturalized here, are entitled to. You're telling me that somebody who's here illegally, that already breached our borders, broke our laws to come here illegally, didn't care about the laws to get here, but now you want them to follow the law for them?
Yes.
Yeah, so the entire point of law
Doesn't
enforcement
that sound
agency is to
hypocritical?
enforce the law. So if they're breaking, so if they're breaking the law to enforce the law, there's no point in having that law enforcement agency around. So yes, illegal immigrants are protected under the Fourth Amendment. That's been cited in Quintana v. U.S. as an unequivocal fact.
And the Ninth Circuit.
In order to enter a home, you need a judicial warrant. They authorize ICE agents to enter homes without judicial warrants as a violation of the Fourth Amendment, obviously.
And the Ninth Circuit already debunked, and let me go grab that one. The Ninth Circuit already debunked when somebody walked in to a home. But most ICE agents have a name of somebody who broke the law.
I thought they did debunk that. Okay.
They did. It's a Ninth Judicial. I just don't know what law it is. But
okay.
But ICE agents, as soon as you're there, as soon as you broke the law and you're here illegally, the judge will automatically sign a warrant for you because they want to come pick you up. And DHS falls under Homeland Security. ICE falls under Homeland Security. They don't fall under your local municipalities. So it's a totally different set of values.
I don't know where you're like just denying reality.
Yes,
so
everything he's saying is true.
The Lyons memo explicitly authorized ICE agents to enter people's homes without judicial warrants.
Okay, but every illegal alien who DHS serves these administrative warrants, which are different than the judicial warrants under the previous administrations, they've all had full due process already and have a final order of removal from an immigration judge.
Fourth Amendment, you're confused.
Sir,
nope, you're confused. I'm talking about the Fourth
it's not.
Amendment. Nope, excuse me.
So the officers issuing these administrative warrants have found probable cause.
So since you want,
hang on, time out. I want to be able to hear everybody speak. Okay, so let everybody speak in their entirety. Let's let Cringy also be able to speak. Okay, we want respect. We have to give it. So go ahead, Cringy.
Illegal immigrants are covered under the Fourth Amendment, U.S. v. Montana. In order to enter somebody's private home or private abode, you need to have a judicial warrant, right? This has been decided in Johnson v. U.S. 1948. So ICE agents are in fact federal officers, so therefore they do need a judicial warrant. They've been authorized to enter people's homes without judicial warrants as a violation of the Fourth Amendment, obviously. If you don't agree with that, then you're just deranged.
Okay, it's not about deranged. The use of the administrative warrants by ICE to arrest these illegal aliens with a final order of removal at their homes is not in violation of the Fourth Amendment right. That is fundamentally false because every illegal, like I just previously stated.
No, those hang on. I do not want to have to keep reiterating myself for 3 minutes and 30 times I have to reiterate the fucking same thing. Please let everybody speak in their entirety. Everybody will be able to speak. You're just going to have to be patient. So, Literate, were you finished?
Partially, but under the federal immigration law, these officers that issue these administrative warrants, this means they have probable cause and finding is made by the executive branch officers in the government rather than a judicial officer. So it's not necessarily in violation of the Fourth Amendment whatsoever. Okay? For decades.
So like in Johnson v. U.S. when they say when the right to privacy must reasonably yield to the right of a search as a rule to be decided by a judicial officer, not a policeman or government enforcement agent, and when Peyton v. York they say explicitly that, or they struck down a U.S. law allowing for police officers to enter homes without a warrant. They said that was unconstitutional. And in U.S. v. U.S., they said that a neutral and detached magistrate has to issue a judicial warrant in order for federal officers to forcibly enter people's homes. What do you think that means?
Slow down a little bit so people can hear you real quick. And then second thing is, since you're talking about this, a couple other guys. So since you're talking about law,
Hey, stop, Cringy.
Let me just ask, since you're talking about a lot of this stuff, a lot of some of the people that are coming over are also claiming that there's an Eighth Amendment violation. Can you explain to me what the Eighth Amendment is?
I never claimed that. I don't know why you're here.
Okay, I'm just asking because here's what I'm doing. I'm trying to depose. Can I talk? You asked to have the same platform and the same respect, so give me the fucking same respect you want.
Yeah,
okay.
I want everybody to be able to speak in their entirety. Hey, Cringy, I understand you can speak fast very well, but when you do that, we may not hear you because it's just a little too fast. So if you want us to listen and hear you out, please just try to slow it down a little bit.
The more on topic this conversation is,
and then I just wanted, because I asked you a question. Hang on.
So,
Can I finish?
Dale, you're gonna have to reply to what he has already.
I know. I'm trying to explain to him why I did that.
He's not replying.
Right. So when you, sir, can I talk? Do you beat your wife and your mom when they talk out of turn? It seems like you have self-control that you can't do stuff.
Like you. Sorry.
Okay.
No,
okay.
We're not. So we're not.
I can put this to bed in 5 seconds. Go ahead.
I just need a quick second. The reason I
do it.
Oh, go ahead.
Okay. So listen.
I was gonna say
cringy.
You guys, please calm down. Like, I just want Dale to finish.
Okay.
I hear you, but I want Dale to finish.
Okay, my apologies.
Jesus fucking Christ.
The reason I asked Cringy about the Eighth Amendment was it's cruel and unusual punishment. And the reason I asked him about that is I wanted to depose. He's spitting out liberal talking facts that he's pulled off of the websites from several prominent. George Soros has a bunch of them and says, here's the cases, here's this. But I asked him that because if he's spitting off and he asked you're violating their Fourth Amendment right? Well, he's got to know what the Constitution says. He didn't even know the Eighth Amendment. He didn't even know that was the first thing that the illegal immigrants were trying to push, their violation of their Eighth Amendment, cruel and unusual punishment, which was one place like Alligator Alcatraz and other places when they were being scooped up by ICE. This shows how disingenuous and how much of rhetoric he's speaking.
Yeah, so I'm just going to
because
somebody gibbering just done by my opponent and going to ask a simple question.
I'm so sorry, but we're going to have to reply to what he has actually said. I understand that you feel that way, that he's doing this and that, but it's not doing anything for the conversation. So
administrative warrants. Yeah.
Okay, so wait, let me finish. Okay, so
I didn't know Texas was done.
Under Johnson v. U.S., do federal officers need to obtain a judicial warrant to forcefully enter people's private homes? Yes or no?
Yes. So administrative warrants are deemed compliant with the Fourth Amendment.
Okay.
The Supreme Court has a.
Thank you.
No, because they're in compliance with the Fourth Amendment. Everything that they're doing is lawful under the Constitution, which is the law of the land, right? So the Supreme Court has literally interpreted that the amendments, reasonableness, are standard to allow for lower non-criminal probable cause in administrative context.
Okay. Excuse me. So under Johnson v. U.S., if you need a judicial warrant in order to enter somebody's private home and they don't obtain judicial warrant, is that a violation of the Fourth Amendment?
No. Like I just stated, the Supreme Court has affirmed the administrative warrants for civil matters. So it's not a contradiction because a lot of these arrest warrants are civil and not criminal.
I can't hear either one of you guys. So y'all figure out how to be an adult, let each other talk, listen. So Banana, who did you vote for? I'm sorry, Banana, who did you vote for?
I voted for Trump. I've been up here a lot, Texas.
Yeah. Did you have anything to say?
I just wanted to say that both of these kids don't really know much. They're soft baby shit. They're like 18, so they don't really got much life experience. It makes sense why they're liberals.
Okay.
I got soft hands.
Thank you for your opinion. Scratch, what is it?
Yeah, I agree with my brother here completely. If you already said that they need a judicial warrant and now you're just like going back in, it makes no sense. Also, like you're saying, the Supreme Court affirmed that. I wonder like what case like you're even citing. Who's in the top here? What literate? Yeah.
We dog walked you last night.
So, did the Supreme Court say that they don't have to have warrants? Or no?
No, the Supreme Court explicitly said in Johnson v. U.S. that a judicial warrant is required.
So, is it can they have suspicion, or what if okay, so there's been cases, I know this, what if they are pursuing them and they go into the house? Do they have to have a warrant?
Yeah, there are certain exigent circumstances in which they can enter without a judicial warrant. But those aren't even. But we're talking in general.
Say something. So there are instances where they have been in pursuit of an illegal alien and they have ran into a home or any other building, and yes, they do not have to have a warrant. Go in then.
Yeah, but that's okay. Yeah, but the Lyons memo authorized ICE agents to just enter homes regardless of those exigent circumstances, solely relying upon administrative warrants. So again, the Supreme Court has ruled.
Oh, I don't know what we're debating. Then they have to have a warrant, and if they do that, and so that those people can sue them if they come in there without a warrant. If they are in pursuit of an illegal alien and they go into a building or a home, they can go in there without a warrant.
Okay, I'm glad you can see that the Lyons memo was that the DHS policy to have ICE officers enter people's homes without judicial warrants is unconstitutional. I'm glad you agree with that.
How many times have they went into people's homes without a warrant?
I'm sorry, do you agree that that policy is unconstitutional?
I've already stated what I needed to state with it, and if you don't like how I've stated it, that's your problem. So, again, how many ICE agents have went into the home of someone without a warrant?
Judicial or administrative?
I'm asking a fucking question. Okay, Answer the fucking question. How many times have the ICE agents went into a home to pursue or find an illegal immigrant without a fucking warrant?
We don't know.
Administrative warrant.
It's several due to
Either one. Both. Give me both.
What are you going to say, 30?
Huh?
I don't think those statistics exist.
What?
The statistics don't exist. He doesn't know.
So you
Great. That's what I wanted to know. Thank you so much.
No,
if it has happened, I'm sure it's minuscule. But if it has happened, then those people can turn around and sue.
What?
Guys. I've barely talked, right? Why would we, this is a literal policy of ICE. It's a policy of the DHS. It's in the Lyons memo. Why would we assume this happened, in a minuscule thing, especially when ICE is doing large operations in Minneapolis and Chicago? Minneapolis, Chicago. Can I finish?
These kids do not.
Can I finish? Or a number.
Can I finish? We can give you. Look, you can look it up. Scott. Wait. Scott Tao was a citizen who was here legally, right? Naturalized, and his house was broken into by a judicial warrant. That's the one case, right? So we have instances of this happen. Wait, give me a sec. So this is imagine there's a CEO, and he says, as a policy, everybody now has to use number 2 pencils when they fill out any form, right? And we look, and we have 5 different instances of employees in the company using number 2 pencils, but we have no other data. Wait, can I finish?
You're on about nothing.
Can I finish? I'm not. It's a policy. It's a stated policy by the CEO of a company that they're using number 2 pencils. We have examples of this happening. It's probably something that's widespread throughout. And this is what's happening.
Okay, so pertaining back to what Cringy was talking about.
We have instances of this happening. Why wouldn't we assume this is probably something happening widespread? It's a policy.
Time out. Do you know what that means? That means shut the fuck up. So I've looked it up. ICE agents have been entering homes without judicial warrants, but specific numbers of homes affected have not been disclosed. Recent reports indicate that ICE has been using administrative warrants to enter homes, which allows for more flexible entry procedures without a judge's approval.
Yes.
However, the exact number of homes entered remains unclear, and there is no official count available at this time.
Okay, so a couple things have been
Hang on. We're not all going to talk at once. We are not all. I am telling you right now, my shit has changed. I'm not letting everybody talk at once. And if you can't handle it, get the fuck off my panel. I want to hear from other people as well, not just you two, okay? I want to hear from y'all, but I don't want to constantly hear. So let's go to Banana, and then I want to go to Polo.
And then can I run afterwards, please?
Yeah.
So I'm asking a question that multiple people, including Millie, had in the comments. Scratch, are you Dean Withers' boyfriend?
No, I'm not doing that. I'm not doing that. And if you do that one more time, I'm going to drop you. So let's go to Polo. We'll go to Polo and then Dale, and then it'll be open. Polo.
Okay. you're saying how many instances, or like what's the statistics on these, like this certain thing happening, or how many people have been affected? Okay, I have a question. If the president of the United States,
I just read it. There is it's unclear how many. It's unclear. Yeah. We don't have the information at this time. We haven't collected the data. So that's out of the question. So go ahead.
Nobody's contesting.
Okay. If any president ever, and it doesn't even have to be anybody, so don't attach labels on this. If any president ever were to enact a policy or piece of legislation that says you can just go on the street and beat the crap out of African Americans, would you ask how many African Americans have been affected by this policy? As a retort.
Sweetie, I'm not even going to answer that. It's nothing pertaining to what we're talking about. Go ahead, Dell.
So scratch. Let me ask a quick question for you. Right? Because we were in several lives and I got kicked off because Chris got mad over me giving him facts. So let me ask a question. Do you know what RATS allows an officer to do?
RATS?
RAS, R-A-S.
RAS? No, I'm not familiar with RAS
at all.
It's called
reasonable articulable suspicion. Okay, all I needed was a yes or no. Reasonable articulable suspicion. That means it gives the same right to bail enforcement officers and everybody else. If I see somebody that
I know what reasonable suspicion allows them to do. If you just said not the acronym.
Hey, no.
Wait, I can answer the question. I can answer the question now that he's explained the acronym because I know what reasonable suspicion is.
You're so misinformed. It's insane.
Okay.
What?
So once you have reasonable articulable suspicion, same as when I was a fugitive recovery agent. If I watch somebody walk into that I already broke the law by breaching our borders, I watch them walk into a house. It's somebody that I'm looking at. I could go in there and I can grab them and I could do that. I just need to know that I saw that person do that. I don't need a warrant to do that. Right? And so that's what reasonable articulable suspicion. It allows you to detain somebody. It allows you to do stuff. That's what.
Yeah, and pertaining to what you were talking about in terms of
Hey, I understand that y'all go on panels and you interrupt people constantly, but you're not going to do that here. I'm going to keep muting you. If I continually have to, I will drop you and you can come back a different day. I'm here for a conversation. I want to hear everybody's opinion in their entirety of it. So please stop interrupting. Millie, how are you doing?
Good. I would prefer Dale to finish what he was saying because I think probable cause and reasonable suspicion is actually very important in these cases. So I'll let Dale finish up what he was saying and then I'll go after.
No, go ahead, Millie. You could piggyback off of that. He didn't even understand what RAS is, and that's something very important for both of you. I
didn't know the acronym.
That we're spouting legislation and court cases, and to not know something like RAS or not know something like that, that's normal nomenclature, and that's crazy to me that they would spout off that and then come back. So go ahead, Millie.
Yeah, so one I wanted to clarify. I didn't say anything in the comments about you guys having boyfriends. I don't really care what your relationship status is. I was only saying that I feel like we're doing Dean Withers hypotheticals, and I just don't think that's really effective in debating. My problem that I have here is that lying on a visa application or lying on a green card application or lying on a naturalization application is fraud. It is a crime, and we have enforced that since way before Donald Trump had become president, so I don't see the issue.
This is like the most awkward enough.
Yeah, so if I can respond to Dale here. This is in the recent 2025 court case, no views for them. So I'm sorry I didn't understand the acronym. I know what reasonable suspicion is, and this is directly I'm reading from the court case. Importantly, reasonable suspicion, right? Reasonable suspicion only means that immigration officers may briefly stop an individual, inquire about immigration status. If the person is a U.S. citizen or otherwise lawfully in the United States, that citizen will be free to go after the brief encounter. So reasonable suspicion, at least in the concept of immigration, can only be used to temporarily stop somebody and inquire about immigration. Now, if they can't produce if you can produce documents, or if you can't produce documents, then that would build probable cause for an arrest, and then for that person to be put into a detention facility awaiting removal, right? But to do the actual arrest, you need probable cause, right? To just temporarily stop somebody, to do a Terry stop, as called, of reasonable suspicion, to inquire about immigration status, that is only that can
So
be
you're
done
wrong.
with reasonable
Okay, but
suspicion.
pertaining to
Really, no, I
administrative
should write the Supreme
warrants.
Court case, so I'm wrong.
Hang on. Let me explain to you where you're wrong. Terry versus Ohio isn't about reasonable suspicion. So that's the Terry stop that you were talking about. I know that court case immensely inside and out, right? Reasonable suspicion was exactly what I said, right? Right? It wasn't. I could stop you because I think you did something. I don't need reasonable suspicion to do a Terry stop. Now, so basically what I was saying was Raz allowed them to stop and detain them to go ahead and ascertain who they are, which allowed them to go into the house. You have not done that. You've strawmanned. You've moved the goalpost 5 or 6 times to make stuff. And then literally, go ahead. You could finish my comment because I know you wanted to say some stuff too.
Oh, okay, yeah. So I'm just trying to tie back into what I think he left at this point. But what Cringy was saying, and maybe
No,
his brother.
he's still here. They're all
He is still here. Okay, brother, administrative warrants that Donald Trump has been implementing, they don't require probable cause because immigration violations are civil and not criminal offenses. Okay, so for allowing enforcement by the executive branch, it doesn't tie into the judiciary branch regarding to what you're saying to where you need a judiciary warrant in order to allow these ICE officers to go ahead and apprehend and detain these illegal individuals. And this is authorized by Congress.
Conceded that.
It's not
You already
conceded.
that under. You already conceded. I asked you the question. You said yes. That was your answer. We can go back in the debate. You said yes. When I asked you under Justin v. U.S., do officers need a judicial warrant in order to forcibly enter private homes? You said yes. So if that is true, and they are
no, but not pertaining to illegal immigration violations that are considered civil and not criminal. So that's where the correlation happens of where you're wrong. You're fundamentally wrong. I'm not conceding to anything. This is just the law of the land under the Fourth Amendment.
Okay.
So everything they're doing, in summary, is still under the Fourth Amendment of the Constitution.
No, you're pulling shit out of your ass. Like what? Excuse me. What case precedent?
And they're signed by.
Allows ICE officers to use administrative warrants in order to enter legal immigrants' private homes.
Dude, are you fucking kidding me? Did I not just explain it to you?
No,
there's nothing further to discuss. It's point blank, period. The argument ends there. There's nothing else to discuss in terms of. I'm sorry?
Okay. I want to go to Scratch. He's got something. What is this, Scratch, before I put it in my box?
So this is an annotation, and I can actually read through it. This is Terry v. Ohio. Under the Fourth Amendment of the U.S. Constitution, a police officer may stop a suspect on the street and frisk him or her without probable cause of arrest if the police officer has reasonable suspicion that the person has committed, is committing, or is about to commit a crime and has reasonable belief that the person may be armed and presently dangerous. Now, as it applies to immigration, that means, and I cited this case right here, and I cited this specific one. This is from 2025, right here, that reasonable suspicion in the concept of immigration means that they can temporarily stop somebody and inquire, right, about their immigration status. I do not know what, Dale is talking about. He just has not read any of these cases. I'm actually, showing it on screen now just so we can make clear. Stop lying about shit that you haven't read.
Tell me when I can talk. Tell me when I can talk. So okay. So go ahead. So go ahead. You said you stopped. So go ahead. So here it is. Terry versus Ohio means that it's not the same thing as reasonable suspicion is about detainment, right? And you and I both know it's about detainment. And I don't need to help you in your investigation when you're doing that. Correct? Correct or not? Since you know about this whole Raz law, stop looking it up and tell me yes or no.
Sorry, I know what reasonable suspicion means? Is that what you're asking?
That's not what I asked.
Sorry, just repeat the question one more time.
Okay, so for a Terry stop, right? A normal stop, I have to be able to articulate the crime you're doing and tell you why I think that your crime is. For a Terry stop, I don't have to do that because of the final part of that Terry stop says if I think that you're doing something, I can hold you, and I can hold you. Most states and jurisdictions have it for up to 60 minutes. Some stop you at 30, but usually if you can't find something in 15 minutes, you can't do it. However, but Raz allows me to go in and get you if I see you walking into a house. Raz allows me to walk into that house and get you out. But like I said before, to show how stupid and fucking disingenuous you are, as I said before, I need to be very, very, very articulate about seeing that that's you before I'm able to go do that. You forgot to do that because no, I didn't. You forgot to do that. Why don't you pull back your recording? Because I know you do that all the time. So pull back your recording.
No, you
He's contradicting himself.
That was literally in the comments. You said Terry Veer had nothing to do with reasonable suspicion. It cites it multiple times. What are you talking about?
Can you hear me? Do you have a hearing problem? Do you need your hearing aids? Please, when I start talking, and I'm asking you guys to chill out for a minute, please do so. It's to everybody. So we're at 297. Absolutely fantastic. Let's kick it up to 320. 320, you guys. Millie, I want to hear from Millie and see if she has any thoughts on this yet.
Well, I think it was kind of disingenuous that you guys defined detainment as being like temporary stop. Like an officer can detain you actually up until charges. It's typically about 72 hours that they have is the usual, but it can actually go longer than that before they actually have to charge you with something. In which case you can file a habeas. I don't know why you're talking over me, Cringy. I think you know how this works. So, really quick, you can file a habeas corpus, by the way, if you think your detainment is unlawful. The court allows for you to do that. The justice system allows for you to do that because accidents do happen. People do end up getting unlawfully detained. And that's why we have a method for recourse when those incidents occur. Now, I'm not going to say 0 incidents have occurred where that has likely happened. I think there have been probably instances where a few people have been unlawfully detained, and that gets rectified through the judicial system, and that's where justice is held to account. Yeah. However, an officer can detain you. An officer can, in a hot pursuit, enter into your home without a warrant if they are in pursuit of chasing you down after they have reasonable cause to believe that you committed a crime.
Nobody was talking
no,
about
that's
that.
not true. Okay,
so first, wait, I just want to clear. So the reason I said briefly stop is because I was citing a court case, and I read that
so the brothers are fighting. Hang on. So the brothers are fighting.
Nobody was talking about that,
so you guys figure out which one wants to go first, and let us know.
I think Scratch already just won.
Okay. What is it, Scratch?
Actually, I was just saying. Yeah, the only thing I was saying. Millie was saying that it was disingenuous for me to call it a brief stop, but that was just what the Supreme Court said, that reasonable suspicion can be used to briefly stop an individual. Because Dale said that in like Terry v. Ohio had nothing to do with reasonable suspicion, and then he was also saying that reasonable suspicion can then be used to like go and arrest somebody, and then he walked back his statements when I like cited the actual cases on screen, which makes sense for somebody as low IQ as him. Second of all, the entire thing was about the fact that the Lyons memo unequivocally just says that anybody can just be can be broken into without a judicial warrant. It doesn't specify any of the circumstances in which that would be like whether it be like in hot pursuit of someone. So I don't know why we're sticking in this really dumb like exigent circumstance when we're talking about the totality cases. This is generally just going to be a Fourth Amendment violation. It's just like this is actually disingenuous.
We've debunked you a million times. You're going in circles.
Listen. I do not believe that ICE agents are intentionally going into homes, knowing that they can't go in there without the warrant.
Nobody said that.
I don't think that that's a thing that's happening. Well, you're saying
nobody said that.
That you are saying that you can't go in without a warrant, and then I asked you how many people you didn't even fucking know. So what is the point then of what you're trying to say? What's the point? What is the point of what you've been saying for the last fucking 10 minutes? Then go ahead.
That's literally what he said. That they can't go in without a warrant.
So I'm going to make the point.
Low IQ.
I was asked a question. I'm going to answer. I was asked a question. I'm going to answer. The point of what we've been talking about is that the Lyons memo and Trump's and the DHS policy under Trump administration is unequivocally prima facie in violation of the Fourth Amendment because it allows ICE officers to enter people's houses forcefully without judicial warrants.
You literally said they couldn't without a warrant.
Bro, how many times are you going to go in circles, okay? There was a memo signed in May of 2025 under the current administration that allows agents to rely solely on administrative warrants, okay? And memos are properly constitutional. So you're literally going in circles on this.
Okay, wait,
in the past, that's how it's been. Historically, agents have been required to hold a judicial warrant or consent to enter a home. Okay, the new guidance literally asserts that the administrative warrants are sufficient to enter residences
so
for enforcement actions regarding federal. So everything that you're saying, you're going in circles.
How does Trump's new guidance overrule court precedent Johnson v. U.S. in 1948?
So memorandums are literally considered lawful under the U.S. Constitution. So that's how it's able to override.
So I asked you, how does Trump's memorandum overrule court precedent?
It's operating as a tool of executive power, okay? So it manages the federal government. So everything that he's doing falls under the guide of the U.S. Constitution.
Hang on. No. Respectfully, you asked a question. Hang on. You cannot hear me if you're constantly talking, man. Now listen. You asked him a question. He's trying to answer you. And when he's trying to answer you, chime in again, man. Can you please just refrain from doing that and let him answer in the way he wants to?
Do you not understand? Yeah, sorry.
If I ask somebody if they like waffles and they start going off about how
so a presidential man. Okay, stop it with your weird. Yeah, stop. The memorandums have the force of law. They're similar to the executive orders, and they're used as direct government agencies, okay, to implement these tasks. Okay, so everything that you're saying, you're trying to have some sort of gotcha moment. But you're just going to continue to go in circles, okay? Because a memo was signed allowing for these administrative warrants.
Can executive orders be unconstitutional according to court precedent?
Can be, but can you show me the current case
okay,
that?
Cool. Just making sure.
Okay, cringy.
Cool. So when Johnson,
hey,
hold on.
Okay, I'm gonna agree. I'm going to
just
now.
goes and runs off the mouth.
Yeah.
Cringy,
So
can you show me the court case where the Supreme Court said that this memorandum is unconstitutional currently?
I can show you the court case where it says that
No, it's not what I asked for. Nope, that's a pivot.
Why?
So, cringy, show me where the Supreme Court or a circuit court has ruled that the memorandum that Donald Trump has put out is unconstitutional.
That's not relevant.
There isn't one.
It's absolutely relevant. No. You can't convince me
what's
that
what's inside of it?
Nope, you cannot convince me that the ACLU did not file a fucking case for Fourth Amendment rights in regards to this. So you're saying that this memorandum is unconstitutional, yet you don't have any judicial review to support that case outside of old cases that are unrelated.
That's what I'm asking.
Okay.
Millie,
That's I just wait.
Okay, wait. I just want.
Can I add? Okay, go ahead. Go ahead, Cringy. Yeah.
Oh, sure. Okay, so I'm just curious. So let me just tell me if this logically follows. If judicial warrants are required in order for federal officers to enter homes, and the Trump administration's policy explicitly allows officers to forgo using judicial warrants, therefore, that policy is in violation of the Fourth Amendment.
You keep reading off of a screen, brother.
Can I respond to that? So, hey, cringy, was Roe v. Wade overturned by a later court?
I'm sorry, does that follow? Wait, I'm just asking.
It does. It does because even under stare decisis, okay, prior precedents can be overturned by a later court. Yes. Okay, so which means that until this case has been ruled upon, and a circuit court or a Supreme Court, our Supreme Court, has ruled that this is unconstitutional, any precedent set prior can be later overturned. In fact, there's been many cases in regard to the Terry v. Ohio situation. There have been flip-flop decisions under judicial review and according to that specific case, that specific instance. So what I am going to ask you is that you provide judicial review for this exact memorandum.
So, Millie, just real quick, if Joe Biden issued executive order, fuck free speech, and went and said anybody who's...
was asking something specifically,
we don't have one. You already said we don't have one.
I'm so sorry.
The question's been answered. The question's been answered.
I want you to answer.
We don't have one. We don't have one right now. We already answered that question. So, Millie, if Joe Biden issued executive order, fuck free speech, anybody who's a Republican and who advocates for Republican values is being arrested and thrown in jail, would you say, well, I couldn't quite say if that's unconstitutional because any court precedent could be overturned? Really, this is just a speculative argument relying on old court precedent in the First Amendment, interpretation of the First Amendment, to say that this is unconstitutional. Would you make that argument, Millie?
Joe Biden's DOJ actually tried to do that with Donald Trump.
Would you make that argument, Millie? Yes or no?
Yeah, actually, this actually did happen because Jack
These
Smith
guys are
tried to
clowns.
attack. Hold on.
Guys, I can never tell something's unconstitutional.
Hey,
You're a clown.
You're not a judge. Ha 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 ha.
Wow.
And you don't have any judicial review to
Y'all are-
support that this
y'all are-
memorandum is
you are
unconstitutional,
children.
and you
Hey.
guys are sitting here coping.
No, absolutely not. Absolutely not. The way you're behaving is absolutely disgusting. You're not even trying to engage in a conversation.
Well, you know.
So,
I'm using my.
I've explained this to you guys
clip
multiple
about
that.
times, and Millie's
Gonna be on
just
his
continuing.
account.
Yeah, so.
Can you guys contain yourself for one moment?
No, they're
You
Yeah,
guys,
they crash out
it goes
whenever they
in
get
one ear,
proven
out the
wrong.
other clearly, because every time I've stated the facts, you keep going in circles on your main point that you're trying to hit
Literally
home.
added nothing to this
Well,
conversation.
court
When we were
president.
talking, you just kept bringing up non-sequiturs. Thank you. Thank you for your time here.
So-
Appreciate it.
So just, I want you to repeat it again, and I want Scratch to actually be genuine that he's going to clip this when he admits that there's not a court filing in regards to this memorandum that's been had judicial review, correct?
Mhm. I don't know if there's a court filing. I don't have a case on hand.
Don't
I
you
might
think
be.
you should have researched that before you came up and debated this topic?
It's Cringy's topic, not mine.
Okay, so you, as of right now, neither of you have that, correct? Yet you're over here jumping out of your seat laughing. Over what? You don't even have any data.
Obviously over the fact that you, Millie, you just admitted that you could never tell something's unconstitutional, right? So this is the problem, right? And we necessarily need to. Can I finish? We necessarily need to do this, right? If some president was saying, President Cameron was saying, I'm going to do these things, I'm like, this is probably unconstitutional according to case precedent, and somebody's response to, well, anything could be overturned. Well, no shit. Anything could be overturned, but rely on, okay, there's probably some court precedent and some interpretation that's going to be around. These are strong constitutional cases that have been used in the past. Let's make an interpretation that this is almost certainly illegal and this is unconstitutional and it's going to be overturned. So it's reasonable to assume, it's almost certain that these certain actions are unconstitutional. If you don't do that, politics is just impossible, right? That's when I asked you a ridiculous hypothetical about if Biden makes the fuck-free speech here and starts throwing Republicans in jail for saying anything. You couldn't say that's unconstitutional because other court precedent overturned is ridiculous. Because we can make these very basic interpretations of the First Amendment and say that's an obvious violation without having to make this dumb argument of, oh, but the courts could overturn it. Like, when you do this, you literally just don't believe in the Constitution as it stands. I'm sorry.
Yeah, did Joe Biden throw women who were protesting abortion and using their First Amendment right to protest abortion? Did he throw them in fucking jail?
Yes.
Did they get charged? Did they get charged, Scratch?
Yes.
Yes.
For exercising their First Amendment?
Yes.
Yes.
I don't know.
That would be a yes. And in fact, they were charged under the same act, Conspiracy Against Rights and FACE Act, by the way, which is what your friend Don Lemon is about to face. Your friend Don Lemon's about to face as well, so buckle up.
So this was a Millie pivot.
He's not
Notice how my
listening.
point was about how we can interpret it. We can show something's unconstitutional about a court ruling, and then Millie pivoted to.
Scratch, do me a favor, and you were yelling about letting everybody else talk.
Yeah, do me a favor.
Give somebody
he's
5
not
minutes
listening.
to be able to have a conversation.
She's
And
just not
you were
listening.
talking
She's like
about.
retracting
Hang
the entire
on,
argument.
can I finish? And stop retracting. You're talking about an educational level just a minute ago, but you guys are the one that said you couldn't enter the house without, and you jumped around without a warrant. And then you just got backtracked and dog walked, and now you're trying to be a top dog where you'd never talk to somebody like that in person, the way you're talking to women here.
I want to get back to the politics. Sandy, who did you vote for?
Trump.
Lovely. How are you doing today?
I'm doing great.
Trump 2028. Let's go.
Did you have any input currently, or do you want to just sit back and respond later?
Well, I just got in. I've been watching you off and on, and I watched you a couple of days ago, and I just love you.
Oh,
and
thank you.
I love the show. But as I just got on, can you just kind of reiterate what you're talking about right now? What are you discussing?
I'm sorry, it's going to take too long to catch up.
Yeah, it will.
I'm sorry, no.
You'll just have to jump in.
Okay, I'll jump in. Go ahead. Sorry.
Okay, so I just want to point out, Scratch, you're the one who pivoted to Biden, correct? Not me.
No, I brought up a hypothetical. No,
pivot?
It wasn't a pivot. It was a hypothetical. It was actually
It's a hypothetical
analogy.
pivot.
No, the hypothetical didn't pivot. So you made the point. No, Millie, you made the point that we can never that we can't tell if something is unconstitutional or not until there's been a ruling, like an EO. And so I was like, do you really I was wondering, does she actually believe that? So I gave you a ridiculous hypothetical of Biden making an EO that was a clear violation of the First Amendment that anybody could tell from a prima facie glance, and I asked you if you would actually think that we would be able to tell that, which that's not pivot, and you said yes, and I said, well, that's obviously ridiculous, and I explained to why it was right. So the point you made was about the point you made about what if we can tell something's unconstitutional or not, and the hypothetical was to confirm that in all cases that was, and then I told you why that was ridiculous. So it was it was clear line of tracking. I'm sorry that you can't actually track the argument. That's probably why you pivoted onto Biden and thought it was a relevant topic.
Well, okay, so Scratch, just really quick. Judicial review is case by case, right? We don't say, well, there's already existing precedent, so we don't need to look at your case at all, correct? That's not how that works. Yes?
I don't know. So when Johnson v. U.S.
No,
says,
just
like,
answer
answer
the question, please.
Okay, I'm sorry. No, Millie, so when Johnson v. U.S. says as a rule, like judicial warrants are to be administered by a neutral magistrate or judge. What do you think that means?
I'm sorry, this is a pivot. Can you answer my question, please?
You don't know what pivot means.
Answer my question.
The Supreme Court. The Supreme Court will sometimes the Supreme Court.
Okay.
It is true that the Supreme Court will refuse.
Okay.
Shut up, dude.
You guys, one at a time. I mean, this is ridiculous.
Opium.
She asked me a question. Can I answer?
Okay, and you guys deflected to something else completely.
So I said not.
What she's saying is true.
So let her speak, please, you guys. One at a time.
She asked me a question. Can I answer it?
If you answer it without pivoting to something completely different other than what I asked you, actually repeat the question. Repeat the question so I know you understand what I asked you.
You asked like if all cases need judicial review. And I said, at least in index to the Supreme Court, I said not necessarily. The Supreme Court doesn't always take up all cases. Sometimes they'll just let it sit at the district level because there's already prior precedent by the Supreme Court, and they think that it's already thoroughly addressed enough, right? So
means that they still have
specifically
judicial
bringing
review.
up this stuff indexed to the Supreme Court, and obviously there's still a judicial review at the district and circuit level, usually just district.
So like Millie, there's a reason. There's a
case
reason.
by case, which means that somebody's prior case isn't your exact case. So when you say, well, there was a prior case that there was a ruling on, so it's likely that we will win this case. It's not the same thing as ruling upon the case that you're currently looking at. So you can't just take prior precedents and be like, well, already prior precedents, so it's immediately unconstitutional without judicial review.
Millie, when there's
That's not how this works.
when there's a previous ruling that says as a rule, right? When it's saying as a rule, it's saying like throughout all of this or during all of these situations, this should be the case. You need to obtain just warrant before you enter somebody's home forcefully. That is precedent applying to multiple situations, which may all be slightly different.
Okay, so really quick, where does the Fourth Amendment say judicial? Does it say judicial or does it
How
say
does that address
warrant?
anything I just said?
Okay, so we're talking about the Fourth Amendment.
Oh. My Fourth Amendment doesn't say judicial.
It doesn't say judicial, it just says warrant, correct?
Okay.
It doesn't lay out that it has to
but
specifically be handed down by a judge. Yes?
It's been interpreted as so it's been
interpretation. There it is.
It's been interpreted as such that under the Fourth Amendment,
interpretation,
that a Fourth Amendment warrant is a judicial warrant. So in order for federal officers to forcibly enter somebody's home, they need to obtain a judicial warrant. And again, when it says as a rule, it's applying to multiple instances, which all could be slightly different or are slightly different. So Millie, again, how about you actually respond to what I say rather than just like bringing up like esoteric bullshit?
One interpretation in this case is very important, and so when we're looking at the plain text of the Fourth Amendment, it does not lay out a judge. It does not lay out any judicial proceeding. It simply just says warrant, okay? And I'm going to remind you of Article 6 of the Constitution specifically says that the Constitution and laws that are passed by Congress are the supreme law of the land. And so the Immigration and Nationality Act and the, H.R. 2002, I believe, if I'm correct, I might have that number wrong, the commencement of ICE as an agency when they establish administrative warrants. Where does it say that it's unconstitutional that Congress creates a new warrant that allows for ICE to do its job?
Okay. So
how's that relevant?
Yeah,
Hold on,
relevant
yeah, how's it
because
relevant? Let's prove it while I look it
interpretation
up
is the
real quick and
key.
get debunked.
Okay.
So just one
Okay.
second. I'll explain this one more time. Okay, the reason why Roe v. Wade got overturned is because a prior court interpreted that the 14th Amendment somehow gave rights for abortion, even though it's not explicitly mentioned in the 14th Amendment. And it says very clearly under the 10th Amendment that anything that is not in the Constitution or in supreme law written by Congress is in the hands of the state. So this is why I said, just because something is precedence yesterday doesn't mean that tomorrow a new precedence can be set.
Millie, is something that wait,
and that's
Millie,
exactly what
I
administrative warrants
I
are
need to add. I need this
compliant
question
with
answered.
the Fourth Amendment.
Millie just went on a rant.
The Urkel twins love to talk over people.
I'm not talking specifically to you. I'm talking to everybody on the panel. There's 3 people that chimed in and tried to talk for more than 1 second. You guys have got to stop doing that. One at a time. Cringy, go ahead, and then we'll let Scratch, and then we'll let Literate, okay? Because y'all 3 were all talking at the same time.
I see my time to Scratch.
It's okay, Millie. Is something the interpretation of the Constitution until overturned otherwise? If the Supreme Court makes a ruling, is that the precedent until overruled otherwise?
Yes, but there's not a current challenge to this.
So if what Cringy cited.
No, listen to what she just said.
No. Cringy, say the case one more time for everybody.
No.
Johnson v. U.S.
Hey, no, I'm so sorry.
She did this to
I'm
us.
going to continually talk over you guys like you do everything else. I'm going to do that too because nobody can hear you or me talking at the same time, right? So, Cringy, or Scratch, you asked something, and then Millie was trying to reply, and you interrupted her. So stop doing that.
She said yes. That's all I needed.
Question.
No, I want to hear what she said. You don't even know what she said. She didn't just say yes.
She did the same thing to us, where she asked a yes or no question and then steamrolled afterwards.
You guys this whole entire time, and if you want to come back on my page, you'll follow the rules or get the fuck off. Millie, what did you say again?
Listen, there's no current challenge to this memorandum. There is no ruling in regards to this memorandum. And until you have that, you have to challenge these things. It's not like, oh, there's current precedent, so we just let it be. You have to challenge it because you're talking about co-equal branches of government. Co-equal. Okay? The executive branch is in charge of enforcing the law. That is what's given to them by the Constitution. Law enforcement. That is the purpose of the executive.
We at least concede that under current precedent that this memo is illegal.
Yeah, I would say under current precedents. Okay. However, you have to challenge. Cool. You have to challenge the memorandum and then have a court determine that.
We got what you need. It's currently violation of the Fourth Amendment. We did. That's all we need. Cool.
Okay. No, it's not.
That's a concession.
No, it's not.
You just said it's under current precedent. It's like a constitution.
That's not how that works.
Well, you just said that, Millie.
I know.
My immediate walk back.
It's terrible. It's terrible when you have children on your panel that you cannot talk without them interrupting you. I'm going to have to get you guys some crayons so you will be able to be distracted and maybe be quiet when other people are talking, right? So please stop for the last time.
Yeah, keep pushing up forehead sentences, buddy.
Millie.
That's why you have a hat to cover it.
Great. I love the personal insults. Whatever you fucking think of me, I really don't give a fuck. Absolutely don't.
He was talking about me.
So, go ahead.
He was insulting me.
Okay. So, if under judicial review, which, by the way, when was that case ruled upon, Cringy? The one that you mentioned?
1948.
1948. That case specifically.
Yep.
Okay. Mm-hmm. When was the Immigration and Nationality Act passed?
Not in 1948.
1965 or something.
Okay, so this ruling, by the way, that you're referencing is prior to the Immigration and Nationality Act, which is new supreme law, by the way. So you would have to.
Well, I mean, there's also another case. So Pato v. New York.
Which one?
In 1980. So yeah, Pato v. New York. Payto v. New York held that a New York statute allowing for police officers to enter homes with force without a warrant was unconstitutional.
That's not ICE.
In 1980.
That's not one that's not federal, one that's not under the Immigration and Nationality Act, which is important to distinguish because when you pass supreme law and they allow the executive to conduct certain investigations that separate themselves from state law. So federal law enforcement, state law enforcement, two separate things. Don't interrupt. Sure. Don't interrupt. Okay. Federal law enforcement, state law enforcement, two separate things. Okay. The next thing that I'm going to point out is enforcement of state laws versus federal laws for immigration are also two separate things. So this is why I said that this is going to be ruled on a case-by-case basis, and it has to correlate directly to ICE and the Immigration Nationality Act.
Okay, so US v. US said that executive officers don't qualify as neutral and detached magistrates, and you need a neutral and detached magistrate in order to issue a warrant, a judicial warrant. In 1970.
It's an issuing a warrant. That's an issuing a warrant, a judicial warrant. So again,
judicial
what I said to you,
or issued by an officer of the judiciary.
That's about an issuing.
Are offered by an officer of the executive branch.
Yeah, that's about it issuing, not whether or not administrative warrants can be used in order to pursue a criminal into a home.
They're saying warrants given by executive officers, so these would be administrative warrants, do not qualify for you cannot use those to forcibly enter people's homes. They're saying it needs to be a judicial warrant from a neutral and detached magistrate, 1972.
That's prior to ICE being an agency, correct? That's prior to the Patriot Act, correct?
Okay, are ICE federal officers?
Yes, but this is prior to, this is, again, prior to, Cringy, don't interrupt, okay? When we passed the Patriot Act, did we sacrifice certain Fourth Amendment rights when that act was passed? Did it start to limit Fourth Amendment rights?
I'm assuming so.
It did.
The answer would be no.
New warrants. In fact, FISA warrants, by the way, and FISA warrants allow for people to be actually spied on without their actual knowledge that they're being spied on.
Okay, I don't know. Like,
does legislation overrule the Constitution?
Okay, so pull up the Supremacy Clause really quick and read it aloud.
I wasn't asking you to tell me to look something up. I was asking you to answer my question. So hopefully you can answer it, Millie, because that wasn't an answer to my question.
Hey, Scratch, if you read the Supremacy Clause, okay, I don't know why you ask questions and then crash out. So under the Supremacy Clause, they are the same. It does not say that the Constitution is above supreme law and laws that are passed by Congress. It says that the Constitution and the laws of the United States are the supreme law. That's what it says. That's why I asked you to read it aloud to the class, and then you crashed out.
I didn't crash out. That just wasn't an answer to my question. That wasn't an answer to my question.
Read Article 6 and answer your own question.
Millie, do you think when I asked, does legislation override the Constitution, do you think that's like an answer to my question?
I just
would say read Article 6? After I asked it, you then criticized me for asking the question. I wasn't crashing out. You just didn't answer the question.
You did. You started going off for no reason. Listen, I have to hand it to your brother. He's a lot more easy to have a conversation with than you are, Scratch. Like, you crash out really quick for no reason. Article 6.
His crash outs are justified.
That wasn't even a crash out. That was just interrupting because you didn't ask the question. Cool.
Yeah, under your interpretation, Cringy, right? That's where interpretation comes into play, because I interpret it as a crash out.
Just under the fact that
you interpret it as being justified. Welcome to the judicial.
I just have like a really low tolerance.
And she didn't even call you uneducated or an idiot or anything. She just said you crashed out. At least she's civil enough to be cordial, unlike the both of you guys.
I mean,
part of being civil is answering questions.
I answered it for you, except for you were too busy crashing out to hear my answer. So what was my response to you?
If somebody asks me what is reasonable suspicion, and I say read page 5 of known viva squeeze, that isn't an answer. That's not. I'm not telling them what reasonable suspicion is. No, you didn't. The first thing you said is read. The first thing you said is read Article 6. So I then interrupted you and said, no, answer my question. That wasn't a crash out. You didn't initially answer the question.
Scratch.
I didn't
Scratch.
like.
So
I know it's really hard for you to like track the argument once again. Kind
you
of a
didn't
thing
track
on your
the conversation
part.
at all.
Maybe you should try it.
Okay,
what are
so
you talking about? That's what happened.
Hey, let
did you not say read Article 6 after I answered my question? Yes or no, Millie?
Let me ask your brother.
Did you say read Article 6 after I asked my question? Yes or no, Millie?
Yeah, really quick. You're not tracking the conversation, Scratch. So, Cringy, did I say not even about 5 minutes ago when I was explaining supreme law that the Constitution and the laws that are passed by Congress are supreme law of the land? Did I not just say that
I mean,
5 minutes ago?
You're just like misinterpreting the supremacy
Yeah.
clause, which
It's
is
not
which,
misinterpretation.
yeah, okay. No,
then
you
read
were.
it.
I don't know. You're just
Then-
you're just bullshitting
then
again.
read it.
To try to get out the argument you lost. So the supremacy clause interpretation is generally people interpret that to be that federal law trumps state law. Nobody interprets it that laws passed by Congress are the exact same as the amendments.
Read it.
Obviously.
I didn't say the same as the amendment, ding dong. I said read Article 6. Read it aloud for the class, please.
Can Congress? Wait, excuse me. Can Congress
Read
pass
it.
laws that are in? Wait, can Congress pass laws that are in violation of the First Amendment?
Oh my god.
They cannot, and that's for judicial review. However, until judicial
That was the
review,
question I asked.
That is not
See,
the
you were
question that
tracking.
you asked.
I was completely right.
No, it's
Oh
not.
my gosh.
Okay, so cringy,
Yeah, no,
cringy.
she just
First of
isn't
all,
tracking.
Oh
First
my
of all-
gosh. Actual
first of all-
tracking error.
Let's
You
see
don't
her
know what the
dick herself out of this
Constitution is.
when did the Supreme Court?
True.
Because in Article 3 of the Constitution, there is no given authority for the Supreme Court to throw out laws that are passed by Congress, by the way. They were never given that right. In fact, they ruled upon that right in Marbury versus Madison, okay, that they had the right to throw out things that they thought were unconstitutional if it was passed by Congress, essentially giving
Holy shit.
themselves the authority to override two separate branches of government. So if the legislative branch and the executive branch come together and pass a law, making it supreme law, does the judicial branch get to override two separate branches of government that override them?
According to the current precedent, yeah.
According to who? The judicial branch?
Current precedent.
Wait. So do you think
I don't
that
know.
a
Like, I don't
branch
know why
of
we're
government?
going into. I don't know why.
Nope,
I don't know
don't
why
run
we're going
away.
into like.
Do you think?
Excuse me.
Nope,
I'm not running
nope,
away. We're
nope,
just,
nope, nope.
You're right. You're
Do
literally
you think
floundering
that
away from
one
the argument,
branch
bro.
of government
Okay,
can
so,
give itself
again,
power?
I don't know why we're going into like.
You guys just can't answer fucking questions or like track the conversation. Do you think that the judicial branch can give itself its own power?
According to current precedent, yeah. Everybody seems to agree with that. Yeah.
Oh, so you agree that one branch of government can just say, I have the power to do this, and thus they have the power?
I mean, everybody agrees with this. Everybody follows.
Okay,
this.
then
Our
you don't
system
disagree
works.
with the executive branch
didn't-
memorandum because
the
according
other
to
theory
you,
of-
one branch of government
Okay,
can say, I have the power to do this, thus I do have the power to do this.
Specifically said according to current precedent, yes. Everybody seems to agree with this. I never said according to me. That's being you're being stupid again.
Precedence is established by who?
Right. So just by the way, for the audience, she conceded that under current precedent that the Trump administration policy is in violation of Fourth Amendment. She conceded that. She
No, I didn't.
You literally did.
No, I
It's on
didn't.
recording.
Reading away from your argument to some random esoteric military executive bullshit. Okay. So I'm going to ask you a question.
Got it.
If
when you
Joe
lose
Biden,
it, yeah, when you lose the debate on like the Fourth Amendment and the Biden Trump administration, so you start the contesting the concept of the judicial review, and saying the Supreme Court can't contest the executive action.
I'm just curious.
True.
So,
Okay,
Millie, if I'm just curious,
now
Joe
it's
Biden
my
passed
time
the
to
Eisner
respond.
Break,
Now it's not my time to respond because now the twins are steamrolling again. So when I asked you both, has there been judicial review on this memorandum? What was your response?
No.
I said I don't know.
What do you mean you don't know? Now you don't know? Now you're walking it back?
But
Answer
I
it
just
now.
said I didn't know. I said I didn't know.
Just not
I said I don't know.
Is there any
Yeah, cool.
judicial review on this memorandum? Yes or no?
No.
Okay, so one, I'm not wrong. One, I did not get dog walked on the Fourth Amendment. You guys are making an argument that has not been established by judicial review in this specific case. You can't go say that just because a case was ruled upon this way in a prior court ruling that the future cases in the future are going to be ruled upon in that way. So in case you didn't understand how judicial review works, and I explained this to you with Roe v. Wade, that prior precedence doesn't mean permanent, which means that anything that was under the 14th Amendment in regard to abortion laws got overturned by a later fucking court. So you guys got a, dog whooping and an absolute beating on what judicial review means.
Millie,
I actually wonder. So Millie, if
make sure you clip that scratch.
I see my time to cringy.
Make sure you clip that part where you both sat here quiet about the fact that you don't have judicial review to support your argument on this specific case.
And now she steamrolled. Wait. So Millie's allowed to end.
One, I was already speaking. I was still speaking. and your brother started talking, and then you started saying, I'm steamrolling your brother who interrupted the middle of my fucking sentence. Check yourself before you wreck yourself. Thank you.
So I'm just going to say this really slowly, and I'm not going to get interrupted, and I'm doing this on purpose just because Millie likes to do this too. Millie just got absolutely blown the fuck out. It makes sense coming from a former cam girl that this kind of shit would happen, you know? Like, usually people go,
are you okay?
You guys are so weak.
Are you okay?
Listen, if you get dog walked by a cam girl, that's pretty embarrassing for you, Scratch. I'm not gonna lie. Are we playing Are We Dumber Than a Cam Girl today?
Yeah, Millie again.
I mean, that's entertaining.
Millie again.
This comes from the left, by the way.
Like mother, like son. Like
wait, really quick. This comes from the left, right? So I'm gonna see you go into all of the feminist lives. No, I'm clipping that, Scratch. I'm actually gonna grab that for Texas, and I'm gonna make sure that every feminist that says, my body, my choice, I do whatever I want, and Scratch runs around on this app and says, women can't express their sexuality. Yeah, just make sure that your friends on the Unfuck America
now, they're meeting me, by the way.
Know your position on that.
Yeah, the fact that you
are you shaming women?
Fact that you
Are you shaming women for expressing their sexuality? No, Cringy, see your way out. See your way out. Your brother opened up this can of worms.
The fact that you thought this was a dub is
no. Hey, Scratch. Are women allowed
Can you guys help me mute them? Help me mute them.
Cringy, you don't need to save your brother. He opened this up on his own. So, Scratch, are women allowed to express their sexuality?
Shouldn't. Absolutely not.
Oh, wait. So, why shouldn't they? Because a man told them so?
No, Millie, because you open your legs. Okay.
Wait. I want to say, please.
It was just disgusting, bro.
I have a very short insight. I'm actually a legal scholar.
If
Millie
sure
was a cam girl,
again,
that's the only.
I want to make sure that it's split.
That's the only base thing she's ever done in her fucking life. That shit's based as fuck, Millie. I love that for you.